impecunious individuals who are requesting assessments of themselves.
Here, over there. Glasses? No.
She's wearing a dark suit.
Right over there.
Yes, that's better.
That's her. Okay. I've got a few outstanding things.
I mentioned to her my case because we did court last night. Yes. Oh, wonderful. Okay, I'll let you go. Yes. Are you? And you two are going to use the podium.
Yes, we are.
So,
I'm going first. 15?
okay, if I could ask everyone who's in the room to take their seats, please. We're going to move on to the next item in the program, which is about defending consent and capacity in guardianship proceedings. We have two speakers who are going to share the time allocated here, Jane Meadus and Suzan Fraser. Jane will be speaking first. Jane has worked in private practice, mostly in the mental health law field, and since 1995, she has been the institutional advocate at the Advocacy Center for the Elderly, dealing solely with long-term care and consent and capacity issues. And she has a lot to say, as is evidenced by her 55-page paper. Suzan Fraser is the principal of a two-lawyer firm conducting a public law practice with an emphasis on mental health issues. Suzan is a member of the board of directors of the Advocacy Center for the Elderly. And I believe they've divided their talk, and there'll be time for questions at the end. And again, you can write them down and bring them forward, or if you wave your hand, we'll recognize you. But Jane is going to be talking mostly about the consent and capacity board hearings, and Suzan about SDA proceedings for guardianship. So I'll turn things over to Jane.
Good morning. So we've decided to use the podium so we can't see the little numbers that Jan gives us, so we can talk for however we want. And I'm just going to sit here and read my paper because I know how exciting that would be.
I'm going to hold up these for the audience, and you can just give her the fingers, okay?
I'm here today, just so you know, generally what happens after these things is we get a flurry of calls at our office for questions, and we do encourage the private bar to call our office for any advice that they want to ask, and I know most of the people who are here today are open to that as well. However, luckily for me, I'm leaving on Friday on an extended leave. I'm going to China to adopt a baby, so I won't be there, so feel free to call my replacement, Emily. I'm sure she can answer all your questions. The nice thing about speaking at these sessions, not at the first one, is you get to do some comments on what you've just heard. And I just wanted to make one comment with respect to the mini-Meadus status exams. I know that Brian said in his practice that he uses those tests, and I think there's a real danger for lawyers to use those tests. Unless you're trained on how to use them, I would, be very wary on sitting down and starting asking people to spell world backwards and stuff like that. And there's also always the context, and this goes into consent and capacity board hearings. If you are dealing with a client who is hospitalized, 99 out of 100 times, if they're a senior, they will have been given the test, and they very likely will fail the date, maybe the month. If they've been in the hospital for a long time, they'll probably fail the season. I had a client who failed on the capacity to know where they were in the hospital. She'd been moved 3 times in a week, different wards, etc. So, all of those things come into play, and if those are the things that they're sort of, quote, failing on, it's a problem. And how many people in this room have retired parents or friends who are seniors who are retired who couldn't tell you the day of the week if you paid them? It has nothing to do with capacity. It's just because they don't care anymore. Lucky them. So, you really have to look at these tests. And one of the things that I say in the paper is most of us are very familiar with the mini-mental status exam, or will become very familiar if you're doing those. The clock test is always fun. But there's also a number of lengthier tests. And if your client is going before a board or going to court and you have one of those tests in front of you, make sure you get the instructor's manual, because they're very interesting. Very often what the person is saying that the test is testing is not in fact what it is testing. And it's really interesting to say, well, why did you, what was the purpose of asking this series of questions? Well, I don't know. Sometimes it's very interesting to ask the question, well, okay, you said my client got 75 out of 100 on your very lengthy such and such test. Can you tell me what answers they got wrong? Oh, no, I don't have the score sheet. Well, I think that really just makes that whole test very, there's just no point in them even mentioning it, because they can't tell you what the person got wrong, so it doesn't mean anything. So you have to ask lots and lots of questions about those things. With respect to capacity, at consent capacity boards for instructing counsel, it's something that I do go into in some length in my paper. Karen Lindsay-Skynner was speaking this morning of the woman in the coma who she was representing based on a PGT appointment. And that's not an unusual thing. I had a discussion of it in my paper of a case that I did where the same sort of thing. You can't put necessarily forward any kind of position for the person if you don't have it. You may, in fact, have it from a previous source. You may be able to find out that the person had a previous wish, and you want to ensure that that gets on the record. Because, for example, in a placement issue, if your client has a previous wish not to go into a long-term care facility and you can document that, and there's enough money in the estate, that wish is still compliable, and they will have to stay at home until the estate is, the money is gone out of the estate, and that may include mortgages, reverse mortgages, and that type of thing. It will not make the children happy because they were hoping to inherit that money, but that is the rule. Just to comment on Karen's case, she actually had the woman in the coma found capable. There was a presumption of capacity, and I understand that the evaluator never actually did much of anything. And because there was a presumption of capacity and there was no proof before the board found the woman in the coma to be capable. So that's very good lawyering, I think. And I'm sucking up to the board, but I'm not allowed to appear in front of her anyway. So one of the things that I always tell people is never underestimate your client. We've heard about people telling fantastic stories, and those are often things that will trigger. And you always have to remember that there may be a kernel of truth to whatever your client is telling you. For example, I had a client who told me that they were grinding up babies in the basement of Sunnybrook Hospital and putting them in his food, and that was why he didn't want to eat his food. He knew it was being tampered with, and it was a really horrible thing. Well, in fact, his food was being tampered with. They were grinding up medication and putting it in his food. And he knew that. He didn't know quite what it was they were doing, but he knew that they were doing something to his food. So you have to sort of ask the questions, why do you think that? What is it about? And in fact, there may be a kernel of truth to those things. Capacity hearings themselves may come out of fantastic situations of this type. I had a client who was in hospital and started to tell the social worker who came in to do an assessment with respect to capacity about how, capacity for placement, about how she was a famous writer and she was writing a novel and all this type of thing. And the social worker said, oh my God, this woman, she's obviously not mentally stable and has more problems than we even thought, and called down a psychiatrist who went and did a whole bunch of other assessments, which grew into a whole very complex hearing. So I took a page out of the book by Carla McCaig. Anybody who knows her knows that she used to do a lot of the mental health hearings when she was at Arch. So I trekked up to the Toronto Reference Library and looked up my client's name. I photocopied all her award-winning articles from the Toronto Star and other papers. Interestingly, she'd actually written papers on the horrors of the old home for the aged system, when they were more work homes and that type of thing, and produced them as evidence at the hearing that in fact she was not incapable. She may have been very slow at writing her latest novel, but I have no doubt that she probably was writing notes on it. So you have to look at those things. Just because somebody tells you something that doesn't sound quite right, look at it, ask the questions, see what happens. Then you've got the other side of the story where you go into the apartment of a person, and this happened on, it was, I think it was either the first or one of the very first hearings under the Healthcare Consent Act placement. And the hearing was going to be held in the woman's home, so I went to the home to see her, and she had a lovely apartment. It was very well kept, and I knew she had someone helping her out on occasion. And I sat down and I started asking her the questions, what did you have for dinner last night? Well, who cooked it for you? And she proceeded to tell me that she had chicken, and she explained exactly how she cooked the chicken, and how many minutes you had to cook it at, and all of that type of thing. And she was you could have a totally normal conversation with the woman. Then the telephone rang, and she picked up the television converter and kept saying, hello, hello. I don't know why nobody's answering. She goes, this phone never works. So, you can really, especially people with short-term memory problems and certain types of issues, you really can have someone who seems to be totally competent, but in fact may have issues that they're very able to get over. Clients at hearings, it was mentioned this morning, I've had clients at hearings, and it's a lovely trick of the board or opposing counsel who will say, and who is this sitting beside you? And your clients, if they have short-term memory, probably won't remember who you are. They'll be very clear on things like, I don't want to go into a nursing home, I don't want to, I just want to go back to my house. They understand the issue of how a hearing works, et cetera, and you talk to them, but you get to the hearing and they really haven't a clue who you are. And, they say, oh, she's a lovely lady, and they look at you and they figure you're well-dressed, so they say, and, oh, she went to university, and I've known her for years and years and years. And, that's going to be evidence against them. If they testify, that's going to be evidence against them. But it's just something that, you're going to have to deal with. And certainly before the Consent and Capacity Board, that is not an unusual situation. And it is not any kind of evidence of bad lawyering that your client doesn't know who you are. The board is quite well aware of the type of clients that appear in front of them and the kind of issues that you have. And they're also quite aware that unlike, when you have a client in court and you start asking them questions on the stand, and they generally will give you the answers that you've discussed, you can discuss the questions that you're going to ask with your client for days on end, and when you go into the hearing, they will give you the exact opposite answer that you had discussed previously. And that's expected, and it's certainly not something that someone says, gee, what a bad lawyer, you've done a terrible job. You certainly, one of the issues, and I started my paper with the discussion of the Rule 4, because that's an issue that comes up all the time. I can't tell you how many times I've gone to hearings where even the lawyers on the other side who are, very practiced in the area have said, well, why don't you just give up? Your client's incapable, go home. Why waste everyone's time? Doctors complaining about how much time that I personally am wasting for them. Why would I bother making these arguments? They really hate technical arguments. If there's a form that they had to fill in or sign, or questions that they should have asked or something like that, that's just a requirement, a procedural requirement, and you ask those questions, they go nuts. What does it matter? They're incapable. Well, it does matter. It's a slippery slope. If you don't do those procedural things properly and get questioned on them, what will you be doing next time? And so if you're appearing before the Consent and Capacity Board or on guardianship matters, I think those are things that you really have to look at. You really are protecting the rights of a very vulnerable population, and in very, very serious matters. If they're found to be incapable, they may be having all their decisions taken away from them. They may be put in places they don't want to be. People do see long-term care facilities as being incarcerated. They have probably been upstanding citizens, paid their taxes every year. Veterans are always saying, I fought for my country and now you're putting me away. I don't understand. What did I do wrong? And those are very difficult questions to answer to people who think that they're quite competent. So you really have to go in and, do your best. Your job is not to act in the person's best interest. People get really upset about that. I said that at a speech when the last educational that I did, and someone in the audience, who I don't think was a lawyer, got up and was absolutely just appalled and started screaming at me. I can't believe you're not there to, act in the best interest of these people. You should be helping them get into homes, not arguing against it. Well, that's what the other side is for. Somebody is there doing that, and that is not my job. And in the area of placement, it's probably one of the areas where there is actually more success in this sort of the consent capacity board hearing matters. If you're arguing a treatment issue, you can, I think it's like 98% out of 100, you will not be successful in having your client to be found to be capable. In the area of placement, it's much trickier. The hearings are much longer. Be prepared to have a day-long hearing on a placement issue, because you will have family members there. You will have lots of doctors and social workers. So if you've represented people before the Consent Capacity Board on mental health issues on a Form 3 or something like that, it's usually you, the doctor, the patient, maybe one other person, that's it. Placement hearings do tend to go over many days. You often have family members. Sometimes the family members are at odds with each other. One thinks mom can do fine at home, the other ones don't. So you really have to be very strong and try to explain to people. One of the things that I put in my paper is a discussion about, if you're the lawyer for the person, probably there's at least a number of other parties who are not represented. So, as assistants to the board, you may have to explain things to people. You may have to tell them, this is in fact not a meeting where we're going to sit around a table and discuss what's best for mom. Lots of people think that. Lots of hospital people think that. They're quite perturbed when they discover that this is a hearing and there's going to be questions, answers, and evidence. So have those discussions with even the doctor beforehand. Have you done one of these before? Do you know that you have to provide me with copies of any evidence you're going to produce? So if you're going to produce any kind of paper evidence, you have to produce that. Generally, people will have looked at the record, looked at the hospital record, and be familiar with most of what's in there. But very often they'll write up something beforehand about something that they know because somebody told them, but that you've never heard before. So ask those questions. Do you have anything that you're going to produce? What are you going to produce? Here's what I'm going to produce. These are going to be my witnesses. They don't necessarily always understand the procedures. If you're going to have some technical issues or some very complex legal issues, tell them they should really talk to counsel. Doctors especially generally hate to talk to counsel, but you really have to suggest to them, look, we're going to go on Tuesday and we're going to sit down and I'm going to tell the board these are the legal issues that I'm going to be discussing, I'm going to be bringing out, and the board is going to say to the doctor, are you willing to go ahead? And they're going to go, I don't even know what they're talking about. And then you'll have to break and everybody have to go home and it'll be a big waste of time because they'll be told to get counsel by the board. So it really is important to put in writing, I'm going to be bringing up these issues. There's a recent case, here it is. Have you read the Kosh case? If everybody in this room has not read the Kosh case, go read the Kosh case as soon as this course is finished. There's 2 parts to it. And it is quoted in my paper. I believe I have some discussion on it. That's sort of the seminal case on some of the placement and evaluators issues. And I always like to give the second part of Kosh, which was the costs part of the case, to counsel or to the evaluator, because people think that these evaluations, I can just go in, ask them 5 questions, I'm off the hook, goodbye. In Kosh, Mr. Justice Quinn found that the evaluator had not done the evaluation properly, hadn't probed and verified, did things like, obviously she was incapable because in the middle of the interview she took a cookie out of her purse. The last time I gave this little talk to a group, one of my colleagues was sitting in the office and her and another person from my office started laughing their head off because my colleague had stuck a cookie in her purse to eat later. So clearly, these sort of things, are not necessarily showing you're incapable. But you have to really tell these people that there are some very important issues. In Kosh, their costs were awarded against the evaluator and the capacity assessor. And so this isn't just it's just part of my job, I'm going to sit down and do it. there are some very, very important issues that people need to understand, and to understand that when they're doing evaluations, that they have to do them properly, or they are going to be called on the carpet for them.
Jane, I'm going to have to ask you to wind up now.
Yep.
Thank you.
I could go on clearly forever. Please read my paper, and I think I'll just finish there. Thank you.
Good morning. Please forgive me, I have a cold, as you can tell. I already start with a submucous cleft palate, so I end up having a nasal voice that sounds a little like Ernie Eves, so I apologize. I just asked Jan when the Substitute Decisions Act was proclaimed, and she tells me it was 1995, and if you heard that I was called in 1995, you'll know that I've been dealing with that legislation only because it's been one of my fundamental areas of practice, and when I come to speak on it today after working with it for the whole of my practice, I still feel like a fraud. So it's a complicated area of law because of the issues of representation that underlie it, as well as the legislation. I have two personal experiences which sort of underlie my approach to working in this area. The first is I have a friend who's a professor at Western, and she had a graduate student who did work for her on a project in Africa. She's in development work. And the student came back, and the reports that they started to get from the student's work in Africa was that the student was really starting to make accusations against people. The research wasn't completed. She had alienated all of the project partners from Norway and from Africa, and gave away the laptop computer that had the research data. So when she returned, they couldn't understand what had happened to this graduate student. And of course, she's at the age where people are subject to mental illness, and people say there's an onset of schizophrenia, onset of bipolar disorder. So the people who saw her, she started also accusing her roommates of things. So very standard breakdown in terms of mental health. And the doctor recommended that she take antipsychotic medication together with mood stabilizers. She was very resistant to this and was very much at danger of losing her master's. And about 3 months into this, my friend was speaking to another colleague who works in development work in Africa, and explained the dilemma. And she said, well, of course, everybody's thought about the malaria medication. And my friend said, well, what do you mean? And she said, well, it's a very well-known fact that one of the side effects of malaria medication is the inducing of psychosis. And of course, because the woman was resistant to taking the antipsychotic medication, you have to take malaria drugs after, but by the time the malaria drugs had worn off, and she was finished her course of malaria treatment, the psychosis was gone, and this student was left with rebuilding her life. But it's one indication, or it's one lesson to show that the obvious answer isn't always the answer, and that it's your job, if you're going to work in areas where people's capacity is an issue and you're defending that you actually have to explore what some of the other options are. And you have to look where you might think that what you're seeing is a horse. You have the job to say, is what we're really looking at a zebra? Because it has 4 legs, I hear galloping, it sounds like a horse, but in fact it's a zebra. And that's your job, so you have to learn from the literature what some of the other things might be going on. The other experience is my own personal experience as a patient in the hospital, Toronto Hospital last summer, in which I spent 1 week in the hospital, was discharged too early, came back from the hospital. I was very ill at the time, having lost 35 pounds. When I was readmitted, my chart was tossed in my lap as I sat in the wheelchair, and my diagnosis of celiac disease was right there. And of course, I didn't see the doctor till the end of the day after all the other people had come to tell me and talk to me about adjusting with this disease. So everything happened backwards in the hospital. But what struck me is that because I was so weak and so vulnerable, the nurses were quite harsh with me. I saw all kinds of infection control things being breached. I was terrified when I was there. I knew that my rights were being breached left, right, and center, but I said nothing because I was terrified. And so it taught me the importance of having an advocate and having somebody else who wasn't subject to other people be able to speak for me. And my sisters and my family were very good at doing that, but I was actually terrified. So in terms of just now moving to actually the substance of today, Jan dealt with the Section 3 appointments, and in terms of defense of guardianship applications, it is most infrequently, I find, that the actual person who's to be subject to the guardianship application ends up becoming represented in that proceeding. You often see a battle between siblings, but it is very seldom that a person's actually represented in a guardianship proceeding. There are very few Section 3 appointments being made. It's my own belief that the Section 3 appointment is critical to the protection of rights, not only because the issues in terms of the substance of the matter, whether it's property or personal care, that the person needs to maintain control of those in order to maintain their dignity and autonomy, but also it's critical that the provisions in the legislation, and these are found both in the areas of the Act that deal with personal care and the area of the Act that deal with property, though both of those provisions allow the court and mandate the court to consider the wishes of the person in terms of making the appointment, in terms of considering the management plan, in terms of the duration of the appointment for guardianship, and in terms of the conditions, if any, attached to that guardianship. And those are critical, in my view, parts of the legislation which allow for the person's dignity and autonomy to be protected as much as is possible in the face of the incapacity. And it's your job as someone representing somebody in a guardianship application to bring those provisions to the court, to the attention of the court, so that the court can limit the guardianship order if it's possible. The Act, in terms of guardianship orders, is divided into two parts. The first deals with court-appointed guardians of property, and the second, court-appointed guardians for personal care. The Act has similar provisions for each section. So if you're dealing with property, there is another provision in the personal care which is similar, if not identical, to what must occur. So if you are dealing with that, you need to make sure that you refer yourself to the proper part of the legislation and look to what the Act provides. There was mention of the York case. That was a case that I was involved with. I'm not going to speak very much about it, but the issue of the Section 3 appointment came after the guardianship order was actually made. The guardianship order was made without Mr. York, the incapable person, being represented in the proceedings. So the issue of the appointment came in when Mr. York wished to alter the terms. There were two parts. He wished to substitute his guardian for somebody that he preferred, and he wished to alter the terms of the guardianship order. And so I represented him in that proceeding. And that is something that even if you can't combat the issue of incapacity, you can deal with putting your client's wishes before the court. I'm not going to deal with mechanisms in which to do that. I think the earlier panelists this morning dealt with, gave you some very good advice in terms of obtaining instructions, in terms of identifying who your client is, understanding all of the elements to your client's personality. The other reason, of course, why that is important in the context of a guardianship application, which we haven't really talked about, is to determine whether there are any wishes that your client expressed prior to the alleged date of incapacity or an actual finding of incapacity, which are relevant to the proceedings. And those may be wishes that that were not written down. Those may be things that somebody said before they were found incapable. For example, I never want to go to a nursing home. And lots of people say that, and so the question is, well, did the person mean that they wanted to be left at home, starving, unable to get themselves to the bathroom, or go to a nursing home? And so exploring who your person was, identifying whether there's a specific wish that's applicable to the circumstances, or whether there is something that, it's consistent with the values and beliefs. Those things are all important. So that's your job to sort of determine whether your client has any wish in terms of the proposed guardian, in terms of the conditions that might be attached to a guardianship. The Section 3 appointment, Graham talked about, there are two things that drives his lawyering. One is whether something's advisable, and two, whether he has instructions on that. And it's my view that under a Section 3 appointment, that if you are appointed, that it is essential that you are not driven by what you think is advisable. And that's my personal opinion in terms of, it's important to tell your client what you think is advisable, but if you're under a Section 3 appointment, the person is deemed to be capable to instruct you. The reason I operate under this is for two reasons. First is I think that that's what the legislation dictates. Excuse me. That's what the legislation dictates, but I also think that that the essence is that there would be no way to give power to all of the conditions of the SDA which allow the person's wishes to be considered, which allow conditions to be attached to the order, to be put into effect or to be put before the court without, if it had to be subject to somebody being capable and being able to follow something which is advisable. So I say that. The other aspect of it is that we know from all types of vulnerable populations, whether you're working for children, people with mental health problems, seniors who have capacity issues, that the right to be heard is very important in terms of an individual's liberty. Whether that right will lead to a positive result for your client is a different question, but simply to have your client to be engaged in the process which is going to determine his or her future and manner of care is essential. The last point that I want to make is with respect to defensive guardianship applications for personal care. And you need to look to Section 45 of the Act, because Section 45 of the Act says that a person is capable of personal care. It gives a number of things. It deals with shelter, nutrition, safety, I can't ream out the list, hygiene,
clothing, shelter.
Okay. And in a personal care guardianship application, the judge has to find that the person is incapable with respect to each of those to give total guardianship of the person. But the judge may also find that the person needs to have a guardian only with respect to hygiene, or only with respect to safety, or only with respect to nutrition. And it's your job as advocates to limit the scope of the guardianship order. So I wanted to alert you to that because it's one of the key parts, in my view, of the applications with respect to personal care. So always be alert, because often you'll have assessments where there's a broad finding and the evidence, the capacity evidence, doesn't really address each one of those areas. So I thank you for your time this morning.
We sort of want to stay on schedule, but I would encourage anyone who has a question to put up their hand. And did I see a hand? No. Well, thank you very much, Sue and Jane, for speaking on this topic. I know that the kind of work you do defending these applications is really kind of swimming upstream. I know that from my limited experience in doing them as well, because we really are a society in a rush. And when we talk about, somebody being represented, someone having their voice heard, a hearing with respect to placement that goes on for more than a day, that involves other professionals being in attendance, I think there's a lot of pressure on the lawyer who is defending the person who's at the center of that proceeding to just cooperate and not be a fly in the ointment, not prevent the procedures from just moving along quickly. And it takes this very special kind of lawyer to be willing to stand up for a vulnerable client's right to be heard. Thank you. And I think I just now have to turn things over to Judith.
As we see, there's a common theme. A lot of us keep on talking about giving the power to the client, and that's one of your roles as the advocate. I know this seems so obvious, but the Advocacy Center for the Elderly has been operating now for 19 years, and the one consistent thing that we've heard over and over and over and over again from clients contacting our office is, why don't people listen to me? Why am I not heard? So this is something, it comes up and is such a consistent basis in representing older clients that we really encourage you to really think about that and how important it is for you giving that voice to the client in a lot of these situations. Now, what I'm going to talk about is something that very few lawyers know a lot about, which is long-term care facilities and what we call the paper, navigating the corridors of care, issues that arise in hospital settings and healthcare settings. A lot of people think, well, why are we going to talk about this? Like, what are the legal issues? There's a lot of legal issues, and I think this is an area where clients will be seeking out assistance from lawyers to a greater degree in the future, because there's more and more complex contracts, a lot of issues around consent and capacity arise in these settings. Like in our practice, we've seen a whole variety of issues. The contracts, admission contracts alone for long-term care. These admission contracts are weird and wonderful things. And my congratulations to the lawyers who've drafted them, because some of them don't seem to know the law very well, because they cite legislation that doesn't even apply. We saw a contract the other day that went on and on and on about the Long-Term Care Act. Long-Term Care Act deals with community care. It has nothing to do with long-term care facilities. But there was all kinds of things like you had to comply with the Long-Term Care Act. Okay. And there's provisions like, as I mentioned in my paper, things like you, in the contract, you pre-consent to everything that's done to you while you're living in the facility. That's one of my favorites. The healthcare pre-consent. I think that sort of goes against everything in the Healthcare Consent Act. And like, how can you pre-consent for all the treatment you're going to receive in a place that you're going to be living in probably for a number of years? So these are places where people live. They're not places where people go to die. One of my other favorite things is on a number of facilities have the practice of giving people do not resuscitate orders to sign before they get admitted. Oh, what a wonderful thing. This happened to my sister. She was helping her mother-in-law look at moving into a long-term care facility. And her mother-in-law was a very healthy woman still. She had fallen and broken her hip, and this was, as a result, could not continue to live in her own home and could not afford to pay for the vast array of community care she would have needed. And the public system only provides you with some assistance. So home care is still very, very limited unless you've got money. So when my sister was running around looking at various facilities, 8 of the 10 places she visited had these do not resuscitate directives that were in the kit, the admission kit. And I thought, what a welcoming thing. What a flag to say to people, you're going to come here and die. There's actually, we push the ministry. Part of our work at the Advocacy Center for the Elderly is the law reform aspect. And we push the Ministry of Health, and to their credit, I'm very pleased that Ministry of Health and Long-Term Care issued a directive to all long-term care facilities saying that they could not have blanket DNR directives. So they couldn't say to people, we'll never resuscitate you. And this is particularly important. You've got clients who are a little bit younger, and it's certainly a certain proportion of people moving into long-term care, the CPR is not a good option. It's not going to be very helpful to them if they go into crisis. But there's a lot of people where it can be very helpful. They're healthy. It's not a cardiac issue. Younger clients living in long-term care, it's important to know that they can get resuscitation if necessary. Also, just in general, talking about people being listened to in these environments, it's a different world in long-term care. And I say this very respectfully, I really have a lot of respect for long-term care facilities and staff. But what's very common is their level of knowledge about things like the Healthcare Consent Act, around issues around consent to treatment, is pretty low and often very wrong. A good example of this, I'm working with a physician right now on physicians training around the Healthcare Consent Act, and he's a physician for a long-term care facility. And he tells this story of how in this particular facility, of which he is the physician, they ask people to sign what's popularly known as a levels of care form. I hate these forms. I think they're horrible legal documents. Like they're meaningless because they say things like, if I have this condition, then I want to go to the hospital. If I don't, I want to stay here and die. If I have this, like it's sort of like where are you going to go depending on the level of care you need. Again, it's treated like a pre-consent rather than getting consent to treatment. We've been pushing hard to get people to change these things, but this illustrates why it's important to challenge some of these things. The physician said he got a call one night from a staff person who said, well, Mrs. Smith needs to go to the hospital. There's something, she's in a health crisis, but her level of care form that she signed 7 years ago said that she never wanted to go to a hospital. Okay, so the physician, he's a good physician, he kept on saying, is she lucid? Can you talk to her? What's her directions? Is she capable? And the staff is going, oh yeah, she's capable, she's competent, we can talk to her. And he says, what does she want? She said, well, it doesn't matter. She signed this form 7 years ago. Okay, so that's the kind of thing. A lot of those facilities are very form-oriented, and it's an education process, and we're all pushing to get people to understand there's still a person here, and the physician kept on saying, talk to her, and the staff kept on going, but the form said, and the physician kept on coming back, talk to her. So that sort of gives you a snapshot why these issues are important. The legal issues that come up in this setting and in hospital settings are quite varied. And there's things like the admission contracts, obviously, it's contract law, so you might be asked to review contracts and discuss those. All these things about these different forms that come up. Do I have to sign it in order to get admission? No. Most of these forms, in fact, they're not required. Now, they're obviously good things like advanced care planning is something that's a good thing for the staff to be discussing with the people who move into the facilities. But they don't necessarily have to sign the particular facility form. There could be conflicts with powers of attorney that the client already has, so you might be called to give advice about some of these issues. There's also some things that end up in hearings before the Health Services Appeal Review Board and the CCB, the Consent Capacity Board. So a lot of issues come up. Costs of long-term care. People are spending a lot on long-term care. There's a fair cost for these services, and so before people get into this commitment, they want some advice to such a substantial commitment of finances, and want to manage it the best they can. Also, if you've got a couple who one spouse is living at home and the other spouse is moving into the long-term care facility, it's really good to know about all the money issues, because sometimes there's a lot of things to sort out. We find that in our practice, we have a lot of that kind of thing, particularly because in our practice at ACE, we're representing primarily very low-income people. So how the money is split up is extremely important. So a lot of legal issues arise. Consent to treatment issues. We've actually had a number of hearings, complaints to the College of Physicians and Surgeons, and hearings before the Health Service Appeal Review Board because they weren't getting consents for clients to very serious drugs, like we were talking about neuroleptics. And it's been argued that the standard in long-term care is that they don't have to get consent, they only have to inform people, the individual or the substitute decision maker after the fact. Well, needless to say, you can see that that's not in compliance with the law, and HSARB keeps on throwing these issues back. So there are, again, a lot of role for advocacy in those settings. It's also difficult advocacy because the client still has to continue living there when you're representing them. So there's a lot of diplomacy in this work. It's how do you resolve the problem, yet assist the client in getting their rights, their voice heard in that setting, but they still have to continue living there when you leave at the end of the day. My paper is actually, parts of it are excerpts from a manual that we've done on long-term care law. To convince you that there's a lot of law in this area, I brought the manual. Here it is. I'm shamelessly flogging it. We started writing this manual as a result of the number of calls coming into our office about these issues. We thought it was going to be a 50-page book. You can see this is over 600 pages, and it's now going into its 3rd edition. So there's a lot of law in the area, and this is available from the Advocacy Center for the Elderly. Look at me flogging things. If you're interested in it, it's on our website. There's an order form. But it's also available at a lot of law libraries, and ironically, almost every long-term care facility in the province bought it. So they have it in their library, so you can always access it there if you don't want to get it from us. But this is really to give you an idea. Like my paper is something like 40 pages long. I've just done highlight some of the issues, so all the details are in the manual. I'm going to give you a snapshot of some of these legal issues. When I wrote my paper, I gave you a scenario, a very typical scenario. Elderly man and his wife, he has a health crisis. He ends up in hospital. He now can't return home unless there's a lot of services provided, and they've got to rush around dealing with issues. Their husband is told that if he doesn't leave the hospital and take the first available bed in any long-term care facility, he's going to be charged $500 a day. Other regions, it's $300 a day. Depends on where you are in the province, you get this threat. The wife is running around looking at different facilities, and she's getting things like these DNR orders, these contracts that she's really questioning if they make sense. They're being asked for guarantors. They're being asked for the kids to sign the contract. What are their rights in this situation? Well, how do you give them advice? Well, first of all, I'm just going to start out with the hospital setting. The preliminary issue, can the hospital require the Mr. Smith, this gentleman, to move into the first available bed in any long-term care facility or into a retirement home pending transfer from long-term care, or charge him a per diem if he refuses to leave the hospital? Well, first of all, hospitals are under a lot of pressure to get people out, and there's a lot of pressure to get seniors out of the place. And when they hit this kind of crisis, a lot of things happen fast. So there's a lot of pressure. Like my sister's mother-in-law, they kept on saying to her, you have to apply to 27 places, which was every home in the region. Now they can't do that because there's been a reg change that says you can only be on 3 waiting lists. But they kept on telling her every day, and this is a very elderly Hungarian lady who was very scared because she was afraid, what kind of care I'm going to get? Now they weren't jeopardizing her care in any way, but it was that constant threat. She was all very worried. And I finally told my sister, tell them who she's related to. And then when she finally told her, and they said, don't get Judith involved. But that pressure, it's a really hard pressure, and it's a very common pressure. Discharge planners are being pushed by their hospitals to get people out. Can they force you out? Well, under the Public Hospitals Act, as soon as a physician writes the order saying that you no longer need acute care, they can't ask you to leave the hospital. But that's only if you're going to, that you can leave, that you actually don't need continuing care. If you need continuing care, they can't just abandon you, because under the Medicine Act, it would be abandonment, it would be misconduct to just discharge you without getting you to the appropriate place for the care, or making sure that, or you choose to leave yourself, or they help you set up the community services. So can the hospital argue that the patient must take the first available bed in any long-term care facility as one available, even if the facility is not one that they would want to move to? As I said, the reg says that you can pick up to 3 facilities to get on the waiting list. And I say that, get on the waiting list, because there's waiting lists for most facilities around. And in fact, if there's not a waiting list, you start to wonder, what's that facility like? Why is that bed available? But again, I say this respectfully. There's a range of places. Like, you got some great places and other places you wouldn't want to move into for all kinds of reasons. Like for my sister's mother-in-law, she was a Hungarian little old lady. She wanted to move in a place where there were people who spoke Hungarian. And there were lots of places where that was possible. So that's, that was a major criteria, not how the place looked. Didn't have to be that pretty. So and then, in fact, I encourage you, that is not a criteria for picking a long-term care facility, how pretty it looks. It's what the staff are like and how the facility is run. So the place could be old, but it could have absolutely superior care. So that's really the main thing. Anyway, so You can pick up to 3 places to go to. And it's clear under all the legislation, if you read it all together, and there's a couple of, why this area is complicated, because you have to read probably 3 or 4 acts. You have a right to choose the places that you pick. They can't force you into a place that is not of your own choice. The new regulations of the admission make it clear that you can only be on waiting lists for up to 3, but say the bed comes available in the 4th facility, another one. It's not wrong for the discharge planner to say, have you considered this one? Have you consider the one where the bed is available? But they can't require you to replace the list. Now, some hospitals are very creative. They say, well, the patient can pick one, and then the patient has to pick one off the list we provide, and then we choose one for you. No, it's a choice of all 3. So you have that total right of choice. Can the hospital require the patient to move into a retirement home pending transfer into a long-term care facility? No. Retirement homes, there's going to be a section on that this afternoon. Retirement homes are tenancies. Unlike a lot of people believe, they are not private nursing homes. They are not private accommodation that's a health facility. They are tenancies. And I stress that, and I fought a case for 8 years in our office to prove that point. They are tenancies, they're subject to rent control, and they're listed as care homes under the Tenant Protection Act. So you can't force a person to pay rent in a place if they need ongoing health care. And you see, I should have mentioned when I started talking about this, it's not that we want to keep the person in the hospital. The person really wants to move into a long-term care facility. The issue is it the place of their choice? This issue becomes particularly poignant when you're in some areas of the province where there are few nursing homes. I was in Timmins last year. In my office, I get to travel a fair bit in my work. I've got to see all the hot spots of the province. And when I was up in Timmins, I had a couple come up to me at a presentation at a long-term care facility, and they were crying because they had not seen their mother for 4 months. Why? Because Timmins is an underbedded city in an overbedded district, and the health district is gigantic. And their mother ended up getting placed in a facility that was 4 hours away down an unserviced road, so there's not the gas stations and everything else on the road. And when the winter hit, this couple couldn't go see their mother anymore because they themselves were elderly. So that's why they were fighting to get her back into Timmins so they could see her. And she had Alzheimer's, so that their biggest fear is by the time they saw her again, she'd have no memory. And so that's why people fight to get into certain facilities. So I think there is some room, that people, you're going to live there for a long time. It's your accommodation, that you need that right of choice. Can the hospital charge a per diem to the patient waiting transfer into a long-term care facility? The Canada Health Act doesn't permit hospitals to charge patients for care and accommodation, with 2 exceptions. One is if you're going to get what's called complex continuing care or chronic care, but that's not long-term care. It's a different level of care. And the second exception and was a reg that was passed to permit hospitals to charge a per diem that's equivalent to the daily rate for standard accommodation in a long-term care facility, which is $48.69 a day, not the $500 a day that this gentleman was being threatened with. So they could charge the $48.69, and that would be appropriate. We've also dealt with some situations where clients who are awaiting transfer into long-term care are actually receiving psychiatric treatment, and they were billed for this, even the $48.69. The hospitals cannot bill for a psychiatric patient who's in the hospital for care, observation, or treatment of a psychiatric disorder. And this money can add up very fast. That's why I raised the money issues, that they're important issues. So now you're dealing with that issue in terms of the hospital. What issues arise when the fellow's looking at which place to go to from the hospital? As I mentioned, he needs continuing care. It may be that one option is a retirement home. As I said, retirement homes are tenancies where you can purchase care. It's a private pay system. I always am very interested. I think that level of accommodation and that level of care is extremely important, but it always fascinates me when people talk about we have a public health system, and yet we have a complete private pay system for health care for seniors in this way. However, you can find retirement homes which can provide you with the level of care you need. basically you got to pay for it. So so you got to really look at what services that particular homes provide. It's a private operation, so they decide what services that they will make available. And there's rules in the Tenant Protection Act about the costs, how fast they can raise them, but the costs are not regulated. The accommodation is regulated as a tenancy. And I'll leave that for the rest of this afternoon for the discussion there. In long-term care, what distinguishes long-term care facilities from retirement homes is that they are regulated health facilities. They're subject to inspection by the Ministry of Health and Long-Term Care, and the costs are regulated. There's a maximum charge that can be charged for accommodation in long-term care facilities. The costs are raised on a periodic basis. Some of you may know last summer there was a big fight because there was a substantial increase in the rates in long-term care, and there was a big protest. And so there was a pullback on the rates again, although they are potentially going up again. So you've got to look at those costs, but it's a regulated health facility. What you're paying for is the accommodation, and the care services are paid through health dollars. In the paper, I've described to you the long-term care system, because you need to, if you're dealing with problems in this area, you need to know what kind of facility you're talking about and how it's regulated. I was once at a little forum for students at Osgoode Hall Law School, and one of the lawyers was talking about his practice, and he talked about how he had done an inquest and on and on and on. And I was really interested because he kept on talking about this inquest in a long-term care facility. And much to my surprise, after I talked with him, it actually was an inquest in a retirement home. And he hadn't made the distinction between a retirement home and a long-term care facility. You're not going to get the right advice unless you know what kind of facility it is. So in my paper, I've described the 3 different types of long-term care facilities and how you get information about that. I want to make a few comments about the costs. Costs to live in a long-term care facility. On page 8 of the paper, I've given you the chart of the rates. What's important to note is that people are entitled to rate reductions. It's only the senior's income that is looked at in determining a rate reduction. You can get rate reductions for the what's called standard care, or the basic care, basic room. And that's important because the rates are higher than the senior's guaranteed income. This becomes very relevant in my practice, where almost all of our clients only have the public pensions. But to pay for long-term care, you've got your public pension plus you need some other income. But you can get the rate reduced, and it's automatic. The idea is that any senior can afford long-term care. We've even had clients who are sponsored immigrants who have no independent source of income, and they can get admitted without any other payment because there's a need, because they need the health care, and it's a regulated health facility. There are two types of accommodation: basic accommodation and preferred accommodation. And in the paper, I described this. It's a whole conundrum of rooms and what do you get for a room. We've gotten calls into our office where somebody says, well, I'm sharing a room with this other gentleman, and this other gentleman is paying the basic rate, and I'm paying the semi-private rate. How come? And this is because there's been a whole restructuring and new design standards. There's a real push to have the rooms be much more private in nature, because also care levels have gone up, so it's better if the clients are in more private circumstances. So what's happened is the rooms may look like a private room, but they're actually a standard room. And in fact, in some facilities, they only have private rooms, but 40% of every facility has to offer basic accommodation. So you could have 2 identical size rooms and people are paying the same rates. That's just something to know about in working out the prices. But also when people are looking at, they can actually get a lot more privacy for their dollar than they might think they can. Other charges. The operator in a nursing home or a long-term care facility is prohibited from charging any amount for accommodation in excess of the prescribed rate. They can't charge more than that rate. They can charge less, although I've never heard of anybody doing that. And long-term care facilities may charge for some optional services, and the optional services are described in the legislation. But it has to be an agreement in writing. They can't charge you for a service unless you've signed for it and agreed to pay for it. So I've had some clients who have been getting additional services, and in the end, they never agreed to get it, so they didn't have to pay for it. It has to be an agreement in writing. Process for the application for admission into long-term care. This is done through the community care access centers, and I've described in the paper what a CCAC is. They handle all the admissions. They look at eligibility, and they're the processing center. You can't go to a facility and apply to it directly. You've got to go through the CCAC. The legislation confirms that you have to consent to admission. Somebody can't place you there. You have to consent to the admission into long-term care. So a lot of legal issues could arise in the course of the admission process for which a client may seek assistance from a lawyer. One is the capacity issue, because part of the process for the admission is that the evaluator from the CCAC is going to look at, can this person consent to admission into long-term care, yes or no, or do we turn to the substitute? So that could end up being a hearing before the Consent and Capacity Board. There could be a finding that the applicant is ineligible for admission. Now, this may be something that the person wants to challenge, and it's a hearing before the Health Services Appeal Review Board. There also could be a denial by a facility of the application for admission into that particular facility. This is a pure advocacy role that you can play because there's no hearing process. Facilities can't reject people except for under the criteria that's specified in the legislation. They can't reject somebody because they don't have money. In fact, the facilities actually shouldn't know about people's own income in the admission process. They should be just looking at their state of health. They can reject a person on the basis that the facility lacks the physical facilities necessary to meet the applicant's care needs, or the staff of the facility lack the nursing experience necessary to meet the person's care requirements, or other grounds for withholding approval as prescribed by the regulations, but there aren't any other grounds at present. So you can see it's not money, it's only if they the practical reasons, they don't have the staffing. What has happened, though, what we're seeing more of is because people can't afford home care and to supplement the public home care, but they do need long-term care, but the facilities are rejecting them because there's behavior issues. You might end up acting for, particularly a substitute, advocating to help the person get into a facility. And we've had a number of those cases in our office. Just a few comments about admission contracts before I end. As I said, lawyers who've drafted these contracts are often very creative. They're full of exculpatory clauses. I always thought, I learned that in law school, and then you see it in life. and so you can go through a contract and go cross that out, cross it out, cross it out, cross it out. You can't have any of these things. You can't do that. One of my other favorite clauses is the nursing home's not responsible for anything that happens to the person while they're living here. I don't think so. First of all, do you have to sign a contract? Actually, ironically, the legislation doesn't require you to sign a contract. The legislation says there is a deemed contract, so the person doesn't have to sign that horrible agreement. But the facility likes it because the Ministry of Health, when they're doing their inspection, will say, is there a signed contract for everybody in the facility? So they put a lot of pressure on people to make sure there's a contract, because it's that communication issue. We've had some clients who haven't signed the contract, but they sign an acknowledgement that they were told everything and that they knew the content of what was in what forms the part of the contract, so they don't have to sign all these clauses. There's often a push to get a guarantor on the agreements. There's no requirement under law for a person for there to be a guarantor, particularly if somebody's receiving the standard accommodation and they're paying the basic rate. There's no need because it's only the senior's income that's taken into consideration. So I've highlighted some issues about the guarantors in the contract. These pre-consents and all these requirements that you have to have these DNR orders prior to admission to get admitted. All those things can be challenged, can be crossed out. They're not necessary. Some facilities push people to have a power of attorney done before admission. Again, it's not necessary. It's not necessary to use the facility's particular living will form. People can have their own powers of attorney. A lot of practical things. It's really going through the contract and checking out what's there and saying what's legal, what's not. Anyways, I leave that with you. Lots of legal issues, lots of advocacy issues. Some of these issues are also, you may never use them up front. You may not have a client call you directly, but say that if you're a family law lawyer and you're drafting that separation agreement, you better know about those rates. and how those systems work, and can people get admitted, and what's the cost of community care, and all of those issues. So hopefully I've planted something in your mind that you'll remember when you have the client with those issues come up, and more information available through our office if you're interested. Thank you. Now, Jane.
I just wanted to make a comment with respect to the advocating on behalf of a client who has been turned down by a long-term care facility. There are the two specific ways, the physical facility and the lack of nursing expertise. What you'll get back from a facility is a letter saying, we lack the nursing expertise to take care of this person. That is not sufficient. They have to tell you exactly what it is about the person that they can't meet, what an issue it is, so that you can actually advocate for them. And it's quite amazing that when you ask that question, I would say 50 to 75% of the time, I'm told, oh, it was a clerical error. Of course they can be admitted. So you have to, they're supposed to detail in that letter what it was that they couldn't meet. So make sure you ask those questions when you get the letter, because the letter will not say that. It'll just give one of the two statements, and that'll be it.
One of the challenges in this area is that some facilities are looking at a person and saying it's going to take too much time to provide them with the care, but yet those are the very people who may need the admission into the long-term care facility. That's why asking for the particulars is very important, because it's not a justification that the person's going to take a lot of time to provide care for. That's the challenge, and that's the difficult. Like we advocate actually with facilities saying we've got to get changes in the system so that they can better provide the care and have the funding and the staffing to meet those heavier care needs, because those are the people who are ending up in long-term care. Any other questions?
Just one comment, because my fellow state practitioners here, we often have, probably happens to me once every 2 months, where you get the mother and the children come in and say, well, mother wants to transfer all her property to us because she doesn't want to have the charge back when she goes into the nursing home. And I assume this is probably from the time that they used to do the chargebacks. But at one time there was a difference between a nursing home and a home for the aged, where the home for the aged had the chargebacks against the assets. The nursing home didn't. Clearly that's, my question, that's been eliminated about 1991.
Yeah, I'll repeat that for the tape. It's fellows coming from an estate practice, and they're being asked to transfer all the mother's assets to the kids so that when she moves into the long-term care facility, they can't charge back against the assets. That was under the Homes for the Aged and Rest Homes Act a number of years ago, and that was only for the lower level of accommodation, what was called residential accommodation and not extended care, and that's completely gone. And so what's relevant is the senior's income. They don't even look at the assets, and that's not an issue. So that's not, it's a maximum rate. They can't charge more than the max rate. So it's a very good point you brought up. Other questions?
Judith, just a comment as well. I was just involved in a Substitute Decisions Act application where I was representing an older client, and one of the things that was driving the application and was making it, according to the applicant, urgent was that there was a bed offered in a nursing home, and if the client, or if my client wasn't put in that bed on the date that the bed was offered, that the client was going to be struck off the waiting list and would have to reapply in 6 months to get into a long-term care facility. And thanks to some very helpful advice from a contact we had at a different CCAC, we were able to go back to the CCAC, as well as advice from Jane, who talked about similar provisions in the Healthcare Consent Act that sort of stop that whole application process while the issue of the person's capacity is being resolved before the Consent Capacity Board. There's not a similar provision in the Substitute Decisions Act or the Healthcare Consent Act covering SDA proceedings, but there is flexibility with the CCAC. They can, our contact called it exercise leniency with respect to whether or not they strike an individual off the waiting list. And we did eventually get them to agree that until the matter was finally disposed of by the court, they would not penalize my client with respect to her place on the waiting list. So it's important to understand that there's flexibility there, and whatever you're told, you have to go back and question it on those kinds of things, because that should not drive someone being admitted to a nursing home.
It's really good. You look up the legislation, look up the regs, know the stuff, and then get into negotiation mode. This area of law is, like, because it has never been challenged, like the lawyers who know this area of law are the lawyers who act for the facilities. Very few people act for the clients. And that's why the stuff doesn't get defined. It doesn't, so you can use that to your advantage in many situations, is negotiate, talk. Ultimately, this is a care system. So you're looking at how do you get the person to provide the care? So getting the law interpreted in that way for that benefit of the person.
How far afield will the Advocacy Center for the Elderly go in representing people, particularly people who are not able to pay a lawyer privately?
How far afield will the Advocacy Center go in representing clients, particularly if a client can't afford representation? We represent primarily clients, I'll call it the Greater Toronto area. It's Greater Toronto because one of my colleagues lives in Whitby and one lives in Barrie, so it gives us a little more flexibility in representation. But we provide a lot of advice over the telephone. And so, particularly, we will also help clients, like if you're calling us as counsel, we can give you a lot of information if you're helping a client in this area, because you may still want to represent the client even though they can't afford to retain you on this because they're retain you for other reasons, for other issues. So this may be an ongoing client relationship. Somebody in my office called it as this is part of your goodwill too, is helping clients in the area. But we will provide. We get calls from all over the entire province. In fact, the other day we got a call from Bethlehem, Israel. So that's a little unusual, but we will take calls from anywhere in the province. Yes.
Who funds your organization?
Who funds the Advocacy Center? We're funded through Legal Aid Ontario. Yeah, I should have done an ad for that. My funder would be upset if I hadn't mentioned that. Yes, we're funded through Legal Aid Ontario. We're one of the legal aid clinics within the system. And as I said, unfortunately, we're still the only clinic of its kind in Canada. But we are a resource to counsel, and we're quite prepared to assist counsel in giving you advice or giving you information if we have it at our source, if that's going to help you with your older clients. Okay, on that note, we're going to stop for lunch until, is it 1:15, Jan? It comes back? 1:15.